There's three things I want to talk about this afternoon quite quickly. The first is advanced care planning. The second is how to access your medical records. And the third is how to make a complaint if something goes wrong. So if we start with advanced care planning, it's something that most people may be vaguely familiar with but not really have much of a handle on what it entails. Essentially what we're talking about is making some plans for what you might want or might not want to happen when you're approaching the end of your life. Now this can be a document, or it can be simply talking to friends and family about what you want. Certainly there's more weight if it's a document when the time comes. There's a push from New South Wales Health to get people to think about this sooner, not to wait until they might need this document, but to think at an earlier stage in life about what you might want to happen. So it can be a document that's prepared that can be utilised either for someone who has a chronic and terminal illness and who is in the very foreseeable future reaching the end of their life, or it can be a document that's tucked away for a younger person or even for an older person who might suddenly meet with an unexpected injury or a serious illness and be in an acute stage of their life. So as I said, in an ideal situation, you will discuss this with family and friends, and particularly with the person who may be the one to make decisions for you if you are to lose capacity. So whoever that substitute decision maker may be. And as the time approaches in which it might need to be used, it's very helpful if you've discussed it with the healthcare providers who may be looking after your care. And if there is actually a written document that's provided to those people so they know that you've documented what your wishes are, that will improve the chances that your wishes will be followed. In New South Wales at present, there's no legislation concerning advanced care planning, and there's no document that's a prescribed form to fill in. So there are some examples that are available. New South Wales Health has a pro forma that can be used, but there's no requirement to use that. As long as you simply write down what you do and don't want to happen, then that will suffice to communicate your wishes. Hunter New England Area Health Service has a website called It's All About Talking, which provides a lot of information about what you might consider if you're considering advanced care planning for yourself or for someone else, a loved one or a friend. New South Wales Health also has an information website that has tools and links for providing and planning for advanced care planning, and links to other organisations that may be able to help you directly to prepare a plan. So the take-home message for advanced care planning is just in the same way that you would prepare a will or think about appointing an enduring guardian, it may be worthwhile thinking about how you would like your healthcare decisions to be handled and what sort of measures you would like to be taken or wouldn't like to be taken. The common one is people say, oh, I don't want any heroic measures. I don't want to be kept on life support indefinitely. So those kind of things are things that if you can express in a document, you have a better chance that when the time comes, your wishes will be respected. And the other thing that the research shows is that when people have undertaken this process of advanced care planning, it's a less stressful experience for themselves when the time comes, but it's also less stressful for the family. The person who's making the decisions knows what you want to happen, they don't have to guess, and there's no conflict in the family members. It's not uncommon to see family members who don't know what their loved one wants be in conflict with each other as to what should happen. Should mum stay on life support? Should we take her off? And it's a hard decision no one really wants to make. If you've actually expressed your wishes in a document, it can save the family the burden of making those decisions for you. Okay, so the next topic is accessing your records. So most people would be surprised to learn that your medical records held by your GP or the hospital don't belong to you. They belong to the GP or the hospital or whoever created them. You do, however, have a right to the information contained within the records, and you can request a copy of your records. In New South Wales, access to records held by doctors in private practice is governed by a piece of legislation called the Health Records and Information Privacy Act. And for records held by public hospitals and public health institutions, it is governed by a piece of legislation called the Government Information Public Access Act. So both pieces of legislation set out how to make a request. Essentially, in most cases, a request for access should be made in writing to the doctor or hospital concerned, and then the doctor or hospital is required to respond within a reasonable time frame. For doctors in private practice, that's generally 45 days. For public hospitals, they generally have 20 working days in which to respond. If a doctor does not respond to your request, you can make a complaint to the Privacy Commissioner of New South Wales. If the doctor or the hospital decides not to provide you with a copy, they are obligated to provide you with a written reason as to why they will not provide you with a copy. And if they do not respond at all, then it's deemed that they've refused you access and you can make a complaint to the Privacy Commissioner. Most doctors and hospitals will charge you a fee. It should be an administrative fee only. It shouldn't be seen as a penalty for you wishing to have a copy of your records. For a public hospital, it's generally a fee of $33 unless there's a large volume of copying to be done, in which case the fee will be higher. If the doctor or healthcare professional does not wish to release the records because they think that the person receiving the records may be adversely impacted by the content of the records, then they can voice that concern and the person can choose to have the records released to another healthcare provider of their choice. If a medical practice changes hands and you're worried about what's to happen to your records then, the records should be released to the person purchasing the practice, or to a doctor that you have nominated for the records to go to. If a doctor dies, you can approach the estate for a copy of the records or for the original records themselves. A doctor has an obligation to keep records for adults for at least 7 years and for children for at least 25 years. Okay, so finally, just quickly about how to make a complaint if you're dissatisfied with the service or the care that you've provided or someone you know has been provided by a doctor or a hospital. In New South Wales at present, there's a co-regulatory model between the actual health professional bodies and the Healthcare Complaints Commission. So you can choose to make a complaint for doctors, the Medical Council directly, or nurses to the Nursing Council, or you can simply short-circuit which professional body you should be approaching and go directly to the HCCC. Both bodies will talk to each other regardless with whom you lodge the application. The HCCC probably has the easiest methods for doing it, and so it would probably be the body of choice. A complaint to the HCCC can be made by about any health service provider, including doctors, nurses, pharmacists, physiotherapists, psychologists, and the list goes on. Any person can make the complaint. It can be the person themselves who's received the treatment or care that they're unhappy with. It can be a parent or guardian of the person who's been subject to the poor care. It can be a relative, friend or representative chosen by that person to make the complaint, or it can be another health service provider. So another doctor can make the complaint or another nurse. The complaint has to be in writing. You can go to the HCCC's website and make the complaint online, or you can download the complaint form and then email, fax or post it off to them. Or if you don't want to use their forms at all, you can simply write a letter and post it to them. The written complaint needs to say who was involved, what happened, when it happened, what the concern is, if you've done anything to address the matter, and what you want to happen as a result of making the complaint. If you have extra information or you have copies of the records that support your assertion, then annexing those to the complaint can fast-track the process. Or if you fill in the forms on the HCCC website, you can actually sign a waiver that says the HCCC can access your records directly. The HCCC has a team of internal medical and nursing consultants who look at complaints to determine the merit and for them to decide what to do with it. Once they've got sufficient information to make a decision, they'll make what they call an assessment decision, and that has to be conveyed to you within 14 days of the decision having been made. The HCCC has 60 days in which to get to that point when they've made a decision. Once they've made a decision, there's a number of options open to the HCCC. They can refer the complaint to a conciliation service. They can refer the complaint back to the professional body concerned, where the professional body might choose to take disciplinary action. In some instances, and probably very few, they decide to undertake a formal investigation, and they can only do that where it raises a serious issue of public health and safety or may result in serious disciplinary proceedings against the practitioner concerned. They can refer the matter to another agency, such as the Office of the Aged Care Quality and Compliance, or they can send you back for local resolution with the healthcare provider or that was concerned in the first place. Finally, they can decide that the complaint has no merit and take no action at all. So for aged care complaints, it's a slightly different scheme, and there's a special body set up particularly to deal with aged care complaints. Anyone can raise concerns with that body about anyone's care or any observations they've made about the care in facilities, as long as they are Australian government subsidised facilities. So they can include residential care facilities, home care packages, and home and community care services. People are recommended to first try and resolve the problem with the provider themselves. If they can't do that, or if they're simply not able to approach the provider themselves because of fear of recrimination or any other types of reasons, they can skip directly to lodging a complaint. And that can be made by simply phoning the aged care complaint scheme or by lodging an online form. The types of concerns that the scheme is generally set up to look at are health and personal care concerns, concerns concerning facility equipment, the activities, choice and comfort of residents or elderly people, and communication systems. That's all I have to say.